160.10. Fingerprinting duties of police. Following an arrest or following the rearraignment where he got an appearance ticket and wasn't printed, they have to take fingerprints if he was charged with a felony, a misdemeanor defined in penal law, a misdemeanor defined outside penal law, which would constitute a felony if the person had a previous judgment and conviction, or D, loitering for the purpose of engaging in a prostitution offense as defined in 240.37 of the penal law. Now, actually, 240.37. The John, it doesn't apply to. It's only the prostitute. Because subdivision 2 is for the purpose of engaging in the prostitution offense. Okay, so I don't think that they would get that technical, but it is good to know that the John does not have to get his fingerprints taken. Loitering for the violation of loitering for the purpose of engaging in a prostitution offense. Not loitering to patronize a prostitute. They may take fingerprints. If such police officer is unable to identify a person's identity, reasonably suspects the identification is not accurate given by the person, or reasonably suspects that the person is being sought by law enforcement for the commission of some other offense. When they take the fingerprints, the photograph and palm prints of the arrested person or the defendant, as the case may be, may also be taken. Taking the fingerprints concerning and the submission of available information concerning the person must be in accordance with the Commissioner of DCJS and the facts and circumstances of the crime charged. 160.20. Upon the taking the fingerprints, the appropriate police or agency must, without unnecessary delay, forward 2 copies of such fingerprints to DCJS. They still haven't fucking updated that. Fingerprinting. Duties of DCJS. First, they must classify them and search its records for information concerning a previous record, including any juvenile delinquency or youthful offenders, and promptly transmit to such forwarding police officer or agency a report containing all the information on file with respect to their previous record, or stating that the defendant no previous record according to its files. Such a report, if certified, constitutes presumptive evidence of the facts so certified. If the fingerprint records are not sufficiently legible to complete classification, they must be returned to the forwarding police officer or agency with an explanation of the defects and a request that the defendant's fingerprints be retaken if possible. 160.40. Transmission of report received by the cops. 1. Upon receipt of the report of DCJS, the recipient police officer agency must promptly transmit such report or a copy thereof to the DA and 2 copies thereof to the court. 2. Upon receipt of such report, now that makes sense because we're still handing them out to the fucking defense counsel. Upon receipt of such report, the court shall furnish a copy thereof to the defense counsel, or if defendant is not represented by counsel, to the defendant. 160.45 says that no DA, police officer, or any law enforcement agency employee shall request or require any victim of a sex assault crime to submit to a polygraphic test or psychological stress evaluator examination. And that definition is defined as any person who's the victim of an offense in 130, 255.25, 26, or 27 of the penal law. 160.50. So this is when it's terminated in favor of the accused unless the DA, upon motion within not less than 5 days' notice, such person or his lawyer demonstrates to the satisfaction of the court that justice requires otherwise, or the court sua sponte with not less than 5 days' notice to such person or his lawyer determines that the interests of justice require otherwise and states the reasons for the termination on the record of such action or proceeding shall be sealed, and the clerk of the court shall immediately notify DCJS, the commissioner of DCJS, and the heads of all appropriate police departments or the law enforcement agencies that the action has been terminated in favor of the accused, unless the court has directed otherwise, that the record of such action shall be sealed. Upon receipt of notification of such termination and sealing, they could either destroy or return the fingerprints to the person. Any police department, including the DCGS, which transmitted or otherwise forwarded to any agency of the United States or of any other state or any jurisdiction outside New York copies of the person's records, including those relating to actions or proceedings which were dismissed, shall forthwith formally request in writing that all such copies be destroyed or returned to the police department or law enforcement agency which transmitted or forwarded them, and if returned, such agency shall, in its discretion, either destroy or return them as provided herein, except that those relating to dismissals pursuant to marijuana 17056 or 21046 shall not be destroyed or returned by such department or agency. What? C. All official records and papers, including judgments and orders of a court, including but not limited to court decisions, opinions, or records or briefs on appeal relating to the arrest and prosecution, including duplicates and copies thereof, on file with DCGS, any court, police agency, or prosecutor's office, shall be sealed and not made available to any person or public or private agency. Such records shall be made available to the person accused or to such person's designated agent, and shall be made available to the prosecutor in any proceeding which the accused has moved for an order pursuant to 170.56 or 210.46 of this chapter, and or II, a law enforcement agency, upon ex parte motion in a superior court, in any superior court, or in any district court or New York City criminal court, provided that such court seal the record, if such agency demonstrates to the satisfaction of the court that justice requires the records be made available to it, or III, any state or local officer or agency with responsibility for gun licensing when the person tried to get a license, or the New York State Department of Corrections and Community Supervision when the person's on parole as a result of conditional release, and the arrest is the subject of the inquiry is one which occurred while the accused was under the supervision, or a prospective employer of police or peace officer, or the probation department responsible for supervising the accused when the arrest is the subject of the inquiry is one which accused while he was under such supervision, and where the fingerprints subject to the provisions of the section have been received by DCGS are digital images. Such images may be retained, provided that a fingerprint card of the individual on file with the division was not sealed pursuant to this section or 160.55 of this article. A report of the termination shall be sufficient notice of sealing to the Commissioner of DCGS, unless the report also indicates the court directed the record not be sealed in interest of justice. When the court determines that sealing is not in the interest of justice, the clerk shall include such notification in that determination. Include notification of that determination in any report to such division of the disposition of the action or proceeding. Alright, so this is when it's been terminated in favor of the accused. A. An order in dismissing the entire accusatory instrument pursuant to 470. B. An order to dismiss pursuant to 170.30, 170.50, 170.55, 56, 180.70, 210.20, 210.46, 210.47 was entered or deemed entered, or an order terminating the prosecution was entered pursuant to 180.85, and the people have not appealed from such order, or the appeal has been against the people, or C. A verdict of complete acquittal, D. A trial order of dismissal, and the people have not appealed or they lost the appeal, or E. An order setting aside a verdict was entered and the people have not appealed or they lost the appeal. An order vacating a judgment pursuant to 440.10 was entered and people did not appeal, or they lost the appeal and no new trial has been ordered. An order of discharge pursuant to Article 70 CPLR was entered on a ground which invalidates the conviction and the people have not appealed, or the determination of the appeal has been against the people, or H, where they're all dismissed pursuant to 190.75. In such event, the clerk which impaneled the grand jury shall serve a certification of disposition upon DCGS and upon the appropriate law enforcement agency, which, upon receipt thereof, shall comply with the requirements of paragraphs A, B, C, and D of sub 1. Prior to filing the accusatory instrument, the prosecutor elects not to prosecute such person, and in such event, the prosecutor shall serve certification of such disposition on DCGS and on the appropriate law enforcement agency, and upon receipt thereof, they must comply with those other things. J, following the arrest, the agency, prior to filing of an accusatory instrument but subsequent to the forwarding of a copy of the fingerprints, elects not to proceed further. In such event, the head of the arresting police agency shall serve a certification of such disposition upon DCGS, which, upon receipt thereof, shall comply with A, B, C, and D. K, I. The accusatory instrument alleged a violation in 220 or 240.36 of the penal law prior to the taking effect of 221 of the penal law, or a violation of 221 of the penal law, and the sole substance is marijuana, and the conviction was only for a violation or violations, and 3 years have passed since the offense was occurred. Okay. So if you get locked up for marijuana, and 3 years goes by, they have to destroy the records, I guess. L, an order of dismissal pursuant to 21540. Then it goes on to sub 4, a person where in whose favor the action was terminated prior to the effective date of this section may, upon motion, apply to the court where such termination occurred, upon not less than 20 days' notice to the DA, for an order granting to such person the relief set forth in sub 1. And such order shall be granted unless the DA demonstrates to the satisfaction of the court that the interests of justice require otherwise. A person may apply, if it was prior to the effective date of the section, may apply to the appropriate prosecutor agency for a certification as described in paragraph I or J, granting the person such relief, and such certification shall be granted by such prosecutor or police agency. Oh, okay. So the ones where they decided not to proceed, or the police decided not to go forward, they have to comply. Oh my god, okay. And then 160.55 is fucking huge, probably. Yeah. So, I mean, I know what 160.55 is. These exceptions are termination of what is this? Operating a motor vehicle while ability impaired. And they decided stealing is not in the interest of justice. The clerk of the court shall include the notification. When the defendant was guilty of violation of harassment in the second degree, and it was determined pursuant to 170.10 sub 8-A that it was against the same family member or household, the clerk of the court shall include notification of such determination. So it's loitering, ability impaired, just harassment in the second degree. And I guess the fingerprints don't get sealed. That I'm not reading because they fucks up. They described operating a motor vehicle while ability impaired. and they called it a violation, but they meant to call it a traffic infraction, I think.